If you must seek justice for Mazi Nnamdi Kanu, anyone that want to seek justice for Mazi Nnamdi Kanu must go out of the shore of Nigeria.
And what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu.
The way this case between Mazi Nnamdi Kanu and the federal government of Nigeria is going, if care is not taken, sooner or later, Mazi Nnamdi Kanu may be sentenced if care is not taken. Because the handwriting is on the wall, and there is a masterminded, procedure and process to push him to be sentenced for 15 to 20 years. You will listen to this video now, because there is no law that he contravened. That is the argument in court right now. Though it has been postponed for 24 hours, adjourned for 24 hours, but nevertheless, listen to this video. You will understand what I am actually talking about. To seek justice for Mazi Nnamdi Kanu must go out of the shore of Nigeria. This is what the Mazi Nnamdi Kanu, both lawyers and sympathizers, are saying after leaving the courtroom today. Because as it stands right now, they are saying that there is a systematic process and systematic approach to push Nnamdi Kanu to open a defense against the federal government of Nigeria, so as for them to rope him up and sentence him once and for all. But as it stands right now, Nnamdi Kanu, looking at his eye today and reading his mind today, you could see that this man is ready to go down the drain. But the sympathizers and the family members or the friend and well-wisher of Nnamdi Kanu have actually come out to speak about what is actually going on, because there is no existing law or what Nnamdi Kanu is being prosecuted for.
My name is Right Honorable Obi Agocha. I represent the great people of Ikuano, Umuahia North and Umuahia South Federal Constituency of Abia State. I represent Mazi Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended for the Attorney General to enter a nolle prosequi, at least before the determination of the court. We are very optimistic that Mr. President, that we know is a listening and attentive president, and that he will do the right thing in the shortest possible time. Thank you.
My colleague here would like to... Okay, thank you very much. Yeah, thank you very much. Well, as an ordinary citizen, I'm not speaking now as a lawyer, as an ordinary citizen, if I am brought before a court of law, I should know the law that I have contravened.
Yes.
You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. To what will I be defending? We're in a country where our laws are written. This is not England, where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. The Honorable, did people make that law? It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Mazi Nnamdi Kanu is completely right and within Section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged with in a court with a law that is in existence, not with a law that is not existing. Wonderful. Thank you.
Thank you. Thank you.
Is non-avoid. is not existing in the law of Nigeria. This is why there will be argument back and forth on Nnamdi Kanu to open a defense against the federal government of Nigeria. Although there was a mistake somewhere when Nnamdi Kanu was asked if he was to close the first case and open the other one. They say yes, they want to close the first one and open the other one. And what is the first one and what is the second one? Let me tell you and listen very carefully. The first one was that Nnamdi Kanu was kidnapped from Kenya to Nigeria. So that was the case against federal government, and federal government was already getting fed up of the whole thing, and they were looking for one way or the other to free Nnamdi Kanu, but because of ego and battle of shoulder, they could not know how to let Nnamdi Kanu go. And they got advice from some sons and some top lawyers that this is what federal government should do, and they actually played the game, and they won halfway by allowing Nnamdi Kanu to close that very particular chapter of him being kidnapped from Kenya to Nigeria, because there was a question that was put to the lawyers, to the defense, federal government defense. They asked them, how did Nnamdi Kanu get to Nigeria? How did it get to these courts? And there was no reasonable answers to that question. And that was where the federal government came to a crossroad. But with legal advice and some other people that are Nnamdi Kanu enemies advised federal government to give a soft landing for some what? Let's give something like a soft landing to Nnamdi Kanu so as to open another case to roping. So that was why Nnamdi Kanu had to go as far as sacking his lawyers, because there were so many things, behind sacking his lawyers. It's not as if the lawyers are not good enough, but it was because there was a perceived compromise from his legal team. But that is not the case, or that is not what we are going to be discussing today, because as it stands right now, Nnamdi Kanu, there are plans in place. There are plans in place for him to be sentenced. And Nnamdi Kanu is even saying, if you want to sentence me, let me know what you are sentencing me for. Provide the law that I have contravened in Nigeria. Because before you can be prosecuted, before you can be sentenced to prison or anywhere, or a correctional center, you must be able to prove beyond reasonable doubt the law that particular person has contravened. So bring out the law, bring the sessions, and please, you listen to this video, and I will come back because I don't want to talk too long, so that you understand this thing, what is actually going on in Nigeria better. One thing I must not take out, you can watch the interview, you saw the interview by yourself. You could see all the lawyers, all the sacked lawyer by Mazi Nnamdi Kanu, they were still in court today. They are still following up with the case. It is not as if these guys, they are not good. You could see Maswe, Ejimako, and all of them, they were still in court following up the case. They were good enough. They are good enough lawyers. But the process was truncated, and they were being frustrated out of it, and they were made to compromise the process and all that. This is what actually transpired. How can a lawyer be protesting? The lawyers, they saw it. They saw all this shenanigans coming. They knew that Nnamdi Kanu cannot leave the court or leave the DSS court or the prison with court process. That was why they joined the protest. They joined Showore. They were all behind Showore protesting. As a lawyer, they protested. As a brother, they protested. And as a citizen of Nigeria that know the sanity of what law says, they hit the street and they started protesting. For the first time in history, and Ejimako was picked up. For the first time in history, you see lawyers that are defending a client hitting the street for process. Why? It's not as if they don't have the energy. They were not exhausted in court. They were not tired of going to court, but they were tired of the process. Adjourn upon adjournment and all that, but at the end of the day, nothing comes out. That is why you saw them, protesting, free Nnamdi Kanu now, free Nnamdi Kanu now, free Nnamdi Kanu now. How come? We should ask ourselves all these questions. Do you know most of the lawyers, they are pro bono, free of charge. That was why they were rendering this service pro bono. No cash, no money attached. But at the end of the day, they were tired of Nigeria court and their process and the way they do their OT. But there was a court order that this should be fast forward for 100 days, but more than 300 days, the court is still adjourning upon adjournment. The same vein, or the same way Nnamdi Kanu was arrested, was the same way Sam Ekpa was arrested in Finland. Finland sat on it and they judged the matter. Don't forget that Nnamdi Kanu was arrested before Sam Ekpa. So why should a young Nigeria believe in Nigeria? Why should give all the reason why we should believe in judicial process in Nigeria? Tell me the reason why we should believe in court when all these things are going on. If you want to sentence, I'm neither defending Mazi Nnamdi Kanu, nor am I defending the federal government. But the process is what we are talking about. You subject the people of Biafran or the people Ito unnecessary